Chapter 33 Criminal Procedure Code contains provisions of bail and bonds. Section 436 deals with bail in bailable offences, and sections 437, 438 and 439 deal with bail in non-bailable offences. Which offence is bailable and which offence is non-bailable? An offence is bailable which is so described in the first schedule of the CrPC. If an offence is described as bailable in the first schedule of CrPC, it is bailable. If an offence is described as non-bailable in the first schedule of CrPC, it is non-bailable. That is all. What is the consequence of an offence being bailable or non-bailable? If it is a bailable offence, the accused is entitled to be released on bail. If it is a non-bailable offence, bail can still be given to him, but that will be at the discretion of the court or the police officer concerned. In case of a bailable offence, the accused shall be released on bail provided he is prepared to give bail. At what stage? If he is arrested or detained without warrant by an officer in charge of a police station, then it is the officer in charge of the police station who will release him on bail if he is prepared to give bail. If the accused appears or is brought before a court, then the court shall release him on bail if he is prepared to give bail. Instead of taking bail from such person, the police officer or the court may discharge him on his executing a bond without sureties. This provision indicates that a bail means a personal bond with sureties. Normally, a bail will be required under section 436, but at the discretion of the concerned police officer or court, the accused may be released on executing a personal bond without any sureties also. That is discretionary. A bail is a right. A bond without surety is not a right. It is at the discretion of the officer or the court. There is a special provision for indigent persons. An indigent person shall be released or shall be discharged on his executing a personal bond without surety if he is unable to furnish a surety. This provision was inserted with effect from 23rd of June 2006. It is for the benefit of an indigent person, a poor person who is unable to furnish surety. But how does the officer or the court know that the person is indigent? If the indigency can be determined by other means, it's well and good. Otherwise, the section itself specifies a way by which such identification can be made. Section 436 says, where a person is unable to give bail within a week of his arrest, it shall be sufficient ground to presume that he is an indigent person. So, if a person is arrested and he is unable to give bail for a week after his arrest, and he has been arrested for a bailable offence, in that event, it will be presumed that he is indigent, and if it is so presumed, then by the force of the previous provision, he shall be released on his personal bond without sureties. Subsection 2 of section 436 acts as an exception to the first subsection. It applies when a person has failed to comply with the conditions of his bail bond as regards time and place of attendance. In case a person has failed to comply with these conditions, then court may refuse to release him on bail when on a subsequent occasion in the same case he appears before the court or is brought before the court in custody. Now it is the discretion of the court whether to release him on bail or not. Even though it is a bailable offence, once he has failed to comply with the bail bond conditions, thereafter he forfeits his right to be released on bail as was given to him under section 436(1), and now he is at the mercy of the court, he is at the discretion of the court. The court may release him on bail, the court may refuse to release him on bail. A new section 436A was inserted with effect from 23rd of June 2006. This section makes a half-hearted attempt to set a limit to the detention which a person can undergo before his guilt is proved. This section says that when a person has undergone detention during investigation or trial up to half of the maximum imprisonment specified for his offence, and here his offence means the offence of which he is alleged, of which he is accused. So if he has undergone half of that imprisonment, then he shall be released by court on his personal bond with or without sureties. He shall be entitled to be released by the court if he has undergone half of the maximum imprisonment for the offence of which he is accused. But the court has been given a discretion to keep him in continued detention longer than half of this maximum imprisonment for reasons to be recorded in writing. Since no parameters, no guidelines are given in this section for continued detention of a person beyond half of the maximum imprisonment, this precaution serves only half the purpose. It is essentially left to the discretion of the court whether to release him on bail or not to so release. Lastly, this section provides that no person shall be detained for more than the maximum imprisonment for his offence during investigation or trial. No person shall be kept in detention before his guilt is proved beyond the maximum punishment for his alleged offence.